How's it going? My name is Dave Pannell, real estate broker here, Dallas Fort Worth. If you're looking for a cash offer on your property or a way to maximize the sales price, I'm your guy. I'd love to help you. But in this interview, I'm talking to Ellen Williamson. She's an amazing attorney, 20 years experience. She's done everything from probate estate planning to regular law. So she has a very technical knowledge of everything to do in probate space or in estate planning. This is what we focus on. This is my podcast. We work in probate. Thank you. Enjoy. Bye bye. So, everybody, my name is Dave Pannell. I'm a real estate broker here in Dallas, Fort Worth. Been selling homes since I was 19, so 30 years. But I'm here with Williamson, and you are an attorney at law for probate, and you have your own practice now.
Sure, David. Yeah. So I do, my law firm does estate planning, probate, and guardianship, which are flip sides of the same coin. Estate planning is planning ahead for future death and possible incapacity, and probate and guardianship are dealing with those realities once we get here.
Mm. I just sponsored an event for the uh, Tarrant County Association, the bench bar in April, and I just learned about guardianship there. I ran into a few situations, but they already solved or they assigned a guardian. I didn't really connect it. Some were a lot longer cases than probate, but the two judges that I talked to recommend that I look into receiverships as
Mhm.
a broker.
That's right. That can make sense sometimes as well. Yeah, when we end up having to sell property in a court supervised situation, sometimes a receivership's an option.
Yeah. So, what's your favorite thing about being an attorney? I read your website a little bit about running. I just started again myself. Fast walking now at my age. Let's put it that way.
Hey, it's forward motion, right?
Yeah.
We'll take it. Yeah. Well, I've been practicing now for well over 20 years. I'm lucky to say most of the time I enjoy what I do. I think in my practice area specifically, I have the privilege of getting to help people take care of their families,
Yeah.
whether that's in the form of planning ahead for what will happen someday down the road or helping people walk through the legal issues associated with a loved one passing away or becoming unable to take care of themselves. I know that when someone comes to see me for probate or guardianship, it's not in the happiest season of their life. They're there because something bad happened, or something stressful, and now in the midst of what's already a difficult and maybe stressful time, they've got to deal with the legal process. So it's our
Yeah.
privilege to help our clients walk through that and help them get through that chapter and hopefully make it a little easier on them.
What leads you to go towards this type of practice other than family law or civil law, or what is your kind of your pattern, your direction?
Um, I've done a few things. I didn't start out doing this. In fact, I actually for most of the early part of my career, I was at the Small Business Administration Disaster Assistance Office. Started there right after Hurricane Katrina. Pretty much, I was
Oh,
between
five, yeah.
jobs at the moment, and they said, "Do you have a law license and a warm body? We need you." Uh, so, like, pretty much the whole, I think everybody practicing law at some point cycled through there. But I was there for a while, and then as I was looking to transition, felt drawn back to these areas. I'd gotten some experience in it, actually earlier when I was, um, guess early in my career, or and even I guess while I was still in law school, clerking with another firm.
Right.
So I, thought those were ideas I'd been drawn practice areas I'd been drawn to, felt like were a good fit, and I, I'm in the right place.
Yeah. So you said they come to you obviously when there's a death or some kind of planning for the estate. Is there a time, like for my clients, sometimes it starts off where they don't really know me that well, but through the process, they actually become good friends. Sometimes things go not planned, but not often. But is that the same kind of connection you have with your clients through helping the estates and then that process of being a client?
Yeah, sometimes, and my grandfather, had a car dealership, and his motto was he wanted to provide such good service to his customers. He didn't want to sell them one car. He wanted to sell them seven.
Okay.
And he meant, I want them to buy this car. I want them to feel like they got taken care of so well that when they need to replace it, they come back and they refer their friends and their neighbors. Uh, and in fact, when he passed away, he had been out of the car dealership business for 20 something years, and some of his former customers reached
Uh,
out to the family and said, "We only ever bought from Daniel Motor Company." And
that's
that,
cool.
of course, I hope that none of my clients need me for 7 probates. That would be unfortunate, uh, but I can think of some people that I say, I can connect the dots. And, this one client has generated, a number of people either, maybe they came to us for probate, we need to probate mom's will. And hey, while we're at it, we need to update our own estate plan. And then they
Mm.
refer their friends. And that's the highest compliment we can get is for us to build that kind of relationship with our clients to where they not only come back for their own needs, but they send other people. So we're very grateful for that. And I agree with you. It's really rewarding to get to build that relationship with our clients.
Yeah, I hate to put it in a sense of a book of business, but it definitely that's all my real estate coach currently, that's all he talks about is the vortex. So there's 5 steps of earning that business, and if you could kind of you deliver the results that they require, they always will think of you, even if there's a little bit of issues or holdup. They will hopefully think of you when they have someone else to refer to.
That's right.
So, um, tell me about you wanted to talk about guardianship. Is it something we could go a little deeper on? Have you it's not completed, but handled a lot of the administrator type probates other than just the executor stuff?
I have, and I think what you're describing, eh, so when if somebody has, a nice properly drafted will that provides for an independent executor. Uh, it selling property as an independent executor is basically the same as selling property you own individually. Just you've got to show your letters testamentary, your badge that shows you have authority to act for the estate, and it's a longer signature line because you're not just signing as
Yeah.
Ellen Williamson. You're Ellen Williamson, independent executor. Easy. But what's harder when you have maybe you don't have a will or you have family conflict or that combination, or you have an estate distributee who either is a minor or incapacitated, someone who doesn't have the legal ability to consent to that independent administration, you end up with dependent administration, which guardianship is basically that for an incapacitated person. And with dependent administration, it's basically a game of mother may I with the court. You have authority to do, you can pay your bond premium, you can pay for insurance, you can pay taxes. Pretty much anything else, you've got to go ask the court for authority and say, Judge, can I do this? And you can't do it until Judge says, yes, you can.
Yeah, I've ran into a couple of those in selling houses, and they always seem to be. There's one that was in Arlington, Texas, that it was held up for 5 years, and the guy that passed away was actually he signed a seller finance thing with the tenant, and they lost all the paperwork,
Mm,
so they didn't have any record of it. And then it went on. The heirs were minors; they were 16, I think. No, maybe younger, 15. But they put it on hold. I guess they didn't make any decisions until they both turned 18. So it went on for almost 5 years of being an open probate or open administration. And then we eventually sold the house, but it was hard getting the people out because they thought they actually owned the property. You can
yeah.
speak on that a little bit. Yeah.
That's tough. Well,
Yeah.
and like I said, if you've got uh, if you've got a will that provides for an independent executor, if I've got a client that comes to me for probate and we've got that will, in fact, I've got someone right now that we're doing that, and they said, I really want to be able to sell this house quickly. What will the time frame look like? And I said, as soon as we can get to court and judge admits the will to probate. and you have your letters testamentary. How quickly you sell the house is just a function of how quickly you go get a realtor and you guys get it listed and you get an offer you like and you close.
Hmm.
And so that's, I can tell my client, all I've got to do is get that paperwork in front of the judge and get a court date, and then you're good to go. But when we have to go through a dependent administration, that mother may I process,
Yeah.
it's basically a four-step process. Um, Step one, you've got to file an application for sale of real property. Basically, you're saying, Judge, can I list this property for sale? And then step two is judge reviews. If the judge finds that a sale is in the estate's best interest, judge will sign an order of sale of real property. So basically, yes, you can go list it for sale, but and I've seen attorneys who don't do probate get that order and they think, all right, we're done, mission accomplished. Go hang the
Yeah.
banner and close. Nope. That order of sale just says you have authority to go list this property and go accept an offer. But before you close, come back here and tell me about that offer, and I'll decide if it's in the estate's interest to let you close.
Mm.
So you go out, at this point, you've got your order of sale. You can go list the property. You can go get an offer. You get the offer you like. You can accept that offer, but subject to court approval because you don't have full authority to accept that contract until the judge says yes. So you go accept that contract. You file a report of sale saying, all right, judge, you told me I could go out and sell the property. I'm under contract. Here are the terms of it. Here are going to be the realtor fees. Here's what's getting paid off. Here's what the estate's going to net. And then it's got to be on file for at least 5 days.
Five
Um,
days.
Although as a practical matter, you're probably going to be longer than that because you got to wait till the court can get you in for a hearing. You've got to have a hearing on the record. And the court will hear from the administrator on why they think the sale's in the best interest of the estate. And if anybody disagrees, they get to have their say as well. Generally, the court's going to want to hear about, um, what did you list the property for? What did you ultimately take? Is this the highest and best offer you got? Were you on the market long enough that we feel satisfied that more time wouldn't yield a better offer? If this isn't the highest and best offer, why did you think this was the right one? Which, sometimes the answer is, well, there was a higher offer, but they had financing. So that's a place where we could have lost it because this process could have caused them to lose their their lender or their rate lock, or it was contingent on um, an inspection and maybe they were going to come back with some repairs that I couldn't make, whatever. So the best offer is going to be a cash one with no contingencies
Yeah.
generally. Um,
That's very nice.
and so, you have this report of sale hearing, and if judge is satisfied that yes, I think this proposed sale is in the estate's best interest, now that I know all the details, judge will sign a decree confirming sale. And only once you have that
Mm.
can you actually go to closing. And by law, the deed that the administrator signs is supposed to specifically reference that decree confirming sale because that's the authority that proves that you could do this. So, as you can imagine, going through all those steps takes a while. You
Yeah.
file that application, it has to have what's called posted notice, which
In
really
the
just
newspaper?
means actually on the courthouse steps,
Wow.
or on the wall. As a practical matter, it just means you've got to wait for the clerk's office to issue citation and get it up there, and the court can't act on it until the posted notice return date has passed. So as a practical matter, what that means is you file this thing, maybe it's a month before it's ripe for the judge to review it. Um, and then you get that order, and then you go off, you say, great, now we can list it. Let's go get an offer. You get that offer, you file your report of sale. You can't close till you've had that hearing. So one of the things I found it's really helpful when you've got a dependent administration to have a realtor who is familiar with that process, so that they know and they can set the buyer's expectations as well. And also, of course, make sure the title companies, everybody's got to understand, the administrator's going to sign this listing agreement and we're all going to move forward, but understand we can't close until judge says yes.
Yep.
So that's where, you can imagine that that's not what a buyer necessarily wants to hear. If,
I had
and the
one at
other,
one point. The guy, the one of the heirs was in prison,
Mm,
but he was getting out. So they waited till he was released. It was like 90 days from the time that the judge authorized the sale. It was my first time dealing with what you just described, so I had to learn that in Dallas County. It was even longer, but you have experience there.
I do. Yeah. Our courts, Dallas County has three statutory probate courts. First one came in like the 60s, second one in the 70s, third one in the 80s as population grew. Population's grown a little bit since the 80s, but we don't have more courts.
Yeah,
And so, yeah, it just
we probably
things
need
take a
more.
long time. And our probate courts, I know, I don't know recent figures, but I know they had been saying the filings increased by double digits every year in the probate courts. And I think of those, more of them are guardianship related than probate. And guardianship, every single one of those is a high touch, mother may I type case. So, you can imagine that that means your filing is one of thousands that they're trying
Yeah.
to work their way through.
Well, unfortunately, I subscribe to getting contacts from the courts every month so that I could technically reach out to people in probate. So I see a lot uh, in those courts. So it's just a matter of helping them and getting in touch with them and see what I could do as a broker. What requires the administrator to get a bond of insurance? Because
So
I've done that on one house.
yeah, so whenever you've got a dependent administrator or a guardian of the estate, they're always going to have to post a corporate surety bond, and that's to protect the estate. I mean, all of these rules, all these mother may I type rules, they're
Yeah.
about protecting the estate. They're not about making the administrator or the guardian's job easier. In fact, they're partly to protect the estate from that fiduciary. If I'm bonded on a case, that means if I decided, well, maybe today's the day I retire and I take this estate's money that's sitting in my account and I head off and, go to the Caribbean, um,
It's
that
happened.
bond is, I mean, kind of the same way as, a criminal defendant bond is,
Hmm.
intended to give,
Okay.
make sure you have skin in the game. If I were to run away with that money and I'm the administrator, um, that bond is to make the heirs whole. Um,
Wow. Okay.
and one of the things that's also, actually, I'm glad you brought that up. One of the things that's relevant too is, maybe when that guardian or that administrator got appointed, maybe there were no, maybe the only asset of the estate is the real estate. Um, so maybe the court just set it as at the minimum $10,000 bond, just kind of a nominal amount.
Hmm.
But now when you go sell the property, let's say, $100,000 is going to come into the estate as a result of the sale. The court's going to say, all right, I'm going to approve, I'm signing the decree confirming sale, and your bond has to be increased now because the $10,000 bond amount no longer protects the estate adequately. The bond always has to be at or higher than the level of liquid assets in the fiduciary's possession.
Yeah, because they're about to get that sum of money if it closes. Correct. Yeah,
Right.
that makes sense.
Whereas in an independent administration, either the will can waive bond or all of the distributees can all agree, hey, look, we trust this person. They're not going to run away. We don't need to make the estate bear the burden of that expense.
Wow. Is it in that same topic when someone files for their own estate, like it may be a small estate, but I just sold a house in Hearst that they were just probating the car, but they have a house that was in a trust, so that was already solved for them. But
Mhm.
that's how they got in touch with me because they got my letter. So have you ever had a small estate where they try to file it themselves and it turns into this? 'cause you discover more?
Yes, I've there the estates code has a procedure for something called a small estate affidavit. But basically it says if the if the estate's value is low enough, and there's a couple of things that are excluded when we calculate the value of it, and it happens to be one where you meet all the requirements, instead of having to go have the court make a formal finding of errors and appoint an administrator, if you're saying there's not that much stuff here. Everybody's agreeable, and we don't need an administrator. We don't need someone with authority to act for the estate. We just need proof of who is entitled to the stuff. You can file this small estate affidavit with the court, and judge will review it. If it complies with the statutory requirements, they'll sign an order approving it, and then that's proof you can go take to say, hey, this is who owns, this bank account or this vehicle or this
Yep.
house. What happens, and one of the he's retired now, but one of the judges who used to review those small estate affidavits in Dallas would say of the small estate affidavits that were filed by attorneys, they ended up rejecting a significant percentage of them, at least on the first filing, because something wasn't code compliant. Of
Yep.
the ones that were filed by non-attorneys, by just people pro se, the rejection rate was over 75%. Now,
Wow.
sometimes it gets rejected because it's, oh, you didn't list this quite the right way, but it's a curable problem. But what I've seen sometimes is somebody thought that that was a remedy that they could use, but it actually wasn't. And so it wasn't curable. That wasn't, one of the examples is, um, for example, in order to qualify, you have to have less than $75,000 worth of assets.
Mhm.
Now, your homestead isn't counted in that amount, and it's real
Yeah.
estate that can be transferred with it only if that property still qualifies
Interesting.
as a homestead after your death, which means like there's a surviving spouse that's there, for example. But I've seen it sometimes where somebody says, well, we can do the small estate affidavit. Mama passed away. All she had was the house and a $5,000 bank account, and it's just going to this one kid. Well, that child no longer the house's
Yeah.
homestead character died with the decedent. So now
Right.
that is no longer an option. Um, so then if they come to me, maybe they say, hey, I tried to file this, it got rejected. What do I do now? Then we can say, all right, well, looks like we're going to need a judicial determination of heirship. We need the judge to make a formal finding of who your heirs are.
Mhm.
That's legal proof of who gets the house, who gets the bank account. Maybe now we also need to get you appointed as administrator to have authority to go collect assets, deal with debts, anything like that. Sometimes you just need that judgment declaring heirship. That's enough to prove who gets the stuff. Sometimes we don't also need someone to have authority, but those are the conversations that we have when somebody comes in and they've attempted that do it yourself
Yeah.
option, and it turned out it didn't do what they thought it would do.
The same scenario when people, everybody could sell their own house on real estate, but some people just don't realize the benefit to have someone just overseeing things and guiding that path a little bit more. And understanding when you're looking at the comps overall, those comps are provided by selling with the realtor, and then they try to sell themselves to get the same price, and it typically doesn't work out, like you said. They try to save 6% commission or whatever it is commission, and they actually historically lose 14% on value. So
Yeah. Well, I think whenever you try to do something yourself, you don't know what you don't know.
yeah,
And to me,
good
I've
point.
appreciated on sales, uh, an experienced realtor can tell me, hey, we need to make sure, for example, one of the things you probably tell your clients in probate and guardianship, and I tell mine, that standard trek form calls for a general warranty deed. If my client never individually owned or resided in that house, I'm always going to want an amendment to a special warranty deed
Good point.
to limit their liability. Say, look, they don't know any more than what the paperwork says. Let's limit their liability. And I've never had a buyer's agent have an issue with that in that scenario. Probably most of the time, it would
That's
never have
really
been
good
a problem.
advice.
You want to limit your client's liability. And I think being able to, when someone is selling their own house, or they're selling as an independent executor, you can come in and say, well, if we listed it as is, it would sell for 250, but if you can go put in XYZ repairs, I think we could get it up to 300. Well, in a dependent administration, like, all you can do is what the court's going to allow, and the court's pretty much always going to say, sell it as is. Um, and so a realtor that knows that and says, okay, we need to, we're going to need to be able to get this through court approval. Not only do we need to set buyer expectations, but that maybe is going to, um, you know, that's going to need to be reflected in as we evaluate these comps. We need to recognize we're selling it as is.
Yep.
And as you evaluate, here's these three different offers. Um, this one wants a longer option period. That's going to push us back more. This one's contingent on inspection. This one has financing. Knowing that report of sale process, um, it's helpful to be able to evaluate and say, this is a better offer on paper, but there's a better chance that we lose it because there's all these contingencies baked in.
Yep. Is that the same s- scenario when someone comes to you either in your office or Zoom meeting? Do you do Zoom meetings with
I do.
initial meetings?
I do. We give our clients the choice of meeting in the office or by Zoom.
Nice.
And we all started out using Zoom because of COVID, but
Yeah,
5 years later, I still find better than half my clients prefer it because
me too.
they don't have to build in travel time, and our clients with caregiving responsibilities, you can plan our Zoom for when the baby's napping, or
Yep.
there's a respite caregiver there. So it's a really great tool.
That's awesome. Is there guidance that you uh, give to people? Like, obviously, I told you I reach out to people in probate or file probate. It's just something I've found very beneficial for real estate sales. But also, there's a lot of people that reach out, like investors or people from the Philippines or just different countries now, calling these people and either bugging them about the trash removal, the donations, or the house, estate sale. Is there
Mhm.
initial like warning to the people that are about to go through this process?
Well, you're right. Once you've got that filing, the application for sale, it's public record. So, yeah, that can come up, and you're right. Clients can get, uh, a lot
Inundated.
of unsolicited things. But to
Yeah.
your point too, I think that's also where a good broker can offer value to say, okay, we're going to need to have these repairs done. We're going to need to have an
Hmm.
estate sale. Here are some folks we've worked with before. Do you want me to put you in touch? That can be really helpful. And even for me as a probate attorney, I can say, I know how to get you through the legal process.
Right.
But the realtor may have more relevant connections on some of those kind of practical logistics. And so
Yeah.
to me, that's a real value add when I work with someone who can help with that part too.
I just worked through a deal where it's kind of a cool story. Is that the guy was incapacitated? He had a stroke, but he's healing just fine. But he had a life estate for a property in Mansfield, and nobody heard from him for 18 months. I don't know if he was deceased. There's no record of death. So I was actually purchasing this house as an investor. It was just a piece of land with a mobile home almost falling down. The guy left the house 18 months earlier. He had a stroke, and then he moved in with a new girlfriend. And I found him located way south in Cleveland.
Mm.
And it was the first door I went to, and he answered. And his girlfriend said, "Hey, come on in. We need to deal with this," because they kept getting code violations and warnings. So it's just a great story to first find the guy and then get him to agree to dispose of the property rather than just not ignoring it as because
Mhm.
he had the right to keep it until he passed. But just the warnings and the liens were adding up. So we
Mhm.
had to the person that was the executor, not the I don't know if it was an executor, but he was dealing with the estate as just as affidavit heirship, I believe.
Mm.
But we had to deal with once the title came back, we learned that he was still attached to the property, even though he abandoned it um,
Mhm.
18 months ago. So yeah, good scenario. So I
Yeah.
tracked him down basically.
Yeah. Well, and you're right. Sometimes with these, people own an interest in real property, but they don't have, they don't have the means to maintain it. And,
Hmm.
it's always a better outcome when we can figure out how to get somebody some value for that and unlock that value for them,
Yep,
instead of just having it get lost.
exactly. I'm getting to the point in real estate sales that I used to give people money 5, 6 years ago before COVID or probably before. I would loan people money that I would get paid back at closing, but that turned into being too personal,
Mm.
especially when there's multiple layers. So I got away from that, but I do now list properties as is
Mhm.
so that we could do I call it like a traffic based approach where we listed for 75% of the value according kind of like I take the highest and the lowest of the comps
Mhm.
and I find a middle ground that'd be very attractive for buyers or investors. And then we do 1 day open house after 10 days marketing the house.
Mm.
And I just see that that's the most positive way to get someone in an administration or independent or executive to get the most for the property. And then they know the market value of the property too and the
Yeah.
courts.
Yeah. Well, and you're right. I mean, for someone selling their own property or as an independent executor, they just get to use their discretion. This is the offer I want to take. I don't need to justify it to anybody, but in a dependent, when you know that you kind of begin with the end in mind and you say, well, I know that before I can close on this, I'm going to have to persuade the judge that my client doing this sale is in the best interest of the estate, and part of that is judge understanding, how did we pick this offer? How are we
Yeah.
reasonably sure that this is the best offer? And having it be on the market for some period of time, being able to say, here's how many people came and looked. The courts like to hear, this, we got, you know, ideally, you picked one offer
11
out of
offers.
multiple.
Yeah.
Um, if this is the one and only offer you got, it's helpful to show here, it's not like we listed the property at noon and,
Yeah.
the realtor's buddy put in an offer at 12:01 and we're done. Like, no,
Right.
that's not enough. But here was our process. Here's how we're satisfied that we've done what we can do to get eyeballs on this and to encourage offers. And we feel like this is the best one. Being on the market longer it is not likely to yield something better. Um,
Yep.
so
Yeah, I found that it's just
mm.
beneficial into my business in general to have more people show up to, first I'm doing a good job for the family or the executor, but also I'm building, um, I guess, a list of clients that are looking for such properties too.
Mhm.
And sometimes we do buy houses, but only if it's the right situation. But I prefer to do what you're saying is just put them on the market, wait 10 days, like HUD used to do back in the day for foreclosures when I first started. I got in real estate in '06, sold some new homes for about 3 years as a realtor, and then foreclosures hit. And I just got stuck on the HUD properties, and they always made you wait um, the initial 15 days before they would even consider an investor offer. They
Mhm.
wanted a family to buy that house if there was no foundation or major plumbing work or something.
Yeah. Yeah. Well, and I guess too, one of the other things I'll note, for folks to mull over, if you've got, an independent executor, someone who's able to sell without having to get court approval, maybe the family all agrees, hey, we'd really like to sell this house to,
Yeah.
to the neighbor. The neighbor was helping take care of dad, in his final years, and we want to sell it to the neighbor, and we want to make the neighbor a pretty good deal. We're not gonna, we're gonna sell it to them at a better rate than we would. just the market at large. In an
Yep.
independent, everybody can agree to that. Um, but in a dependent administration,
Ah, yeah,
that's hard. Now, if all of the heirs, if everybody with skin in the game says, "Hey, we understand that we could have listed this on the market and maybe it would have gotten 400,000, but we all agree that we want the administrator to take this offer for 350, and we recognize we could be leaving money on the table and we still agree." Well,
mm,
then I think judge would say, "Sure, that's fine as long as, it as long as that still gives the estate enough assets to meet its needs." But if the administrator just says, "Well, I'm selling to the neighbor because that's just that's what I want to do," judge is going to say that's not in the best interest of the estate.
right,
That the attorney there, or sorry, the administrator has a bond, the judge has a bond too, and the judge's job is to think about what's in the best interest of the estate. And unless all of those heirs all say, "Yes, judge, we agree, we're okay with that below market sale," the court doesn't agree, it is going to have to oppose it. I've seen a case. I was brought in to represent the by the court to represent the interests of a minor in a situation where the decedent spouse had been named as the dependent administrator. Um, Unfortunately, and it was dependent because there was no will and you had a minor heir. A minor can't legally consent to an independent administrator, so even when with nobody disagreeing, you still end up in a dependent. Everybody should have a
wow.
will, but if you have minors, you really, really, really should have one. Uh,
I've got a 2
but
and
what
5-year-old, so I gotta
happened
work on that.
is the administrator's lawyer didn't do much probate work, and they got that order of sale, and they said, "Great, let's go." And they went and closed. Now, the title company should have said, "Hold up, that's not
Yeah,
how that goes." But they ended up selling the house below market value to a family friend. And when this came to the court's attention, um, the judge ordered the sale set aside and said, "No, no." Now, this is one, and unfortunately, there, because it was sort of after the fact, they ended up ultimately reaching a resolution where they got to keep it. But
nice.
um, and it, the minor got made whole. We basically said we need to put the minor in as good a position as they would have been in if this had all been done the right way, and if that happens, fine. But
Good looking out.
otherwise, what would have happened is this sale that everybody relied on gets blown up. You try to unscramble the eggs.
Yeah,
It's messy. But if they had brought that to the court through the report of sale hearing like they were supposed to, then that issue would have been hammered out then, and judge would have said, "Hold up, that's not in the best interest of the estate. If this house could sell for 400 to someone else, you can't sell it to these people for 350. These people will go to 400, great. Otherwise, go to the highest bidder." So that's a
correct.
thing that, this kind of comes back to when people come to me for estate planning. I feel like seeing some of this play out in the real world uh, helps us give better advice to our estate planning clients, where we can
Right.
think about, here's what we need to do with your plan, both for after you pass away and incapacity, because that guardianship process, you're going through all of this, but somebody with a financial power of attorney, I'm sure you've done transactions with
Oh,
them.
yeah.
It's basically the same as selling individually, except you've got to show your power of attorney document and a little longer signature line. Um, so you
And I've
think,
got them where they get them off a line, and they're not acceptable too, so gotta be
yeah,
careful.
do it yourself.
Yeah,
The problem with do it yourself estate plan documents is by the time you realize they don't work, you found out at the worst possible moment.
yeah,
Um,
months and
But,
months.
you think if it's frustrating going through that court supervised process after someone has passed away, you think how much worse it is having to go through that when they're alive and incapacitated, and maybe you're saying, "Look, we need to sell this house to pay the nursing home." Every day delay is costly.
Yep,
Um, and so, I look at it as guardianship's kind of the legal equivalent of emergency room surgery. I'm glad we
Yep.
have it. There are people who are alive because of it. Uh, I think my job as an estate planner is to keep my clients out of the legal emergency room. And the way we do that is powers of attorney. Those are the legal equivalent of preventive care. Or you mentioned a client with a trust, property held in a trust. That's another piece of incapacity planning because now you've got a successor trustee who can step in. So those are, depending on the client, sometimes that's a piece of a plan that makes sense too. But anytime that somebody can sell real property, they're empowered to do it without having to go through that court process. That's going to save everybody time. It's going to save everybody money. It's going to provide more flexibility, and usually that's going to make for a
Yeah.
happier family.
I've noticed a lot of people. Two questions real quick. I've noticed a lot of people don't. They end up not having the trust document that's actually signed. The attorney has the signed copy. What causes? I can't imagine you guys keeping the signed copy from the people. But sometimes when I show up to list a property and it is in a trust, or they get the trust and it's just not signed at all. It's not no notary or anything. It's just like they say the attorney has the copy. Is
That's
that
interesting.
but people lose the survey all the time in real estate too, like the
Yeah.
main document you need to save money.
Right. Yeah, I've got mine. I've got ours nice and locked up on purpose. Um,
Yeah.
no, so I don't know. That's interesting. I've not. I'll say my office. It's not our practice to keep our clients signed originals. I don't think most folks I know do anymore. I think it used to be historically that was what happened. The estate planner would say, well, we'll keep the signed originals nice and safe here in our vault. So they're in a safe place. And I suspect it was also a little bit of, and hey, then you're going to come back our way for the
Yeah.
probate. Um, I think as best I can tell, I I don't know off the top of my head of any colleagues whose practice it is to keep originals. But um, what I see happen with trust-based planning though is a client will come to me and say, Mom passed away. What do we need to do? Well, let's see. What do we got? Well, mom had a trust, and they bring out, it never fails. The bigger and more expensive that leather binder, the less happened afterwards. So I say, all right, well, I see that mom created this trust. Um, do you know if any of her property got funded into it? Oh, I don't know about that. Well, that's kind of the important part. I say, when you create a trust, it's kind of like creating a bucket to hold your stuff.
Mm,
And so,
good
in
way.
fact, I'm going to use this this little prop my daughter made, not for that, but it's just so perfect. Um, so it's this little,
Yeah.
construction paper box. So if I do a consult with a client by Zoom, I say, so if this was your trust, we wrote all the terms of it around the side. We say this is the Pannell family trust, and David's the initial trustee, and if he becomes deceased or incapacitated, this is who the backup is, and everything in this box is for his benefit for the rest of his life. And then after his death, here's what happens. We created this beautiful box. That's that leather binder. The important piece is putting your stuff in it. So she made me
Mm,
these little Oreos because I like to
nice.
snack on Oreos.
I love it.
So I say, all right, well, here's your trust. All right, this is your house. So we're going to fund your house into the trust. So we're going to prepare a deed for you to sign from yourself individually to yourself as trustee. And we can make that effective in your lifetime or only at your death. Here's your bank accounts. We've put those in the trust, or we've named the trustee as beneficiary. Here's your car. Here's, your jet ski, whatever. So
Yep.
everything in there, all those terms we wrote around the side apply to this. Well, any estate plan that includes a revocable trust, we're also going to have what's called a pour over will. And so I say that's kind of the shovel that scoops up whatever didn't make it into this box during your life. And that trust or that will
Interesting.
says, I leave everything to the trustee of my trust. And so, well, let's say, when you were at the attorney's office while you were working with your estate planner, everything you owned at that point went into the box. Great. Those terms cover it. But let's say 5 years from now, you went out and bought a new house and you put it
Yeah.
in your individual name. So it didn't make it in. Well, now all those terms that we wrote on the side of the box don't apply to that new property. The way that property gets in there is we probate that pour over will that says, I leave everything to the trustee of my trust. And that executor says, all right, ideally they're written to be an independent executor, so they get to do all the stuff easily. If my client's the independent executor, then we're going to prepare an executor's deed from themselves as executor to whoever the trustee is, which might also be them. And then that serves to put that cookie in the box. And now the trustee can sell it to the ultimate buyer.
Wow, cool. Yeah. So we're almost out of time. I appreciate it. Do you have I saw in your if you're comfortable talking about how you charge,
Mhm.
how do people pay for the services? How do you prefer that, or how do you describe that for someone?
Sure. So I'll say my office offers for pretty much all estate planning and probate and some guardianship matters, we will offer flat fees. I say we do flat fees the way a painter does flat fees, which is that if you came over and you saw my house and said, "Oh, I like the color on your living room," and you call that painter and say, "Hey, how much would it cost to paint my whole house?" Well, they're not going to give you a number right off the phone. They're going to say, "Well, what I need to do is I need to come out and look. Let me measure the square footage. Let me see the condition of those walls. Let me see if, is it rounded corners? Is it textured? Is it, black paint first that I've got to put 3 coats of Kills on to get rid of?"
Yeah.
Um, once I better know the scope of work, I'll prepare a flat fee quote that says, you know, this is what we're committing to. And, if they get in there and find, oh, there's termites, they're going to go, well, that changes our scope of work, that changes our cost. But when we'll do our initial consultation with our client to, for say estate planning, find out more about what our client's situation is, what they want, what they need, figure out, are we doing a plan where we, create that
Yep.
trust during their lifetime, or are we just creating a will-based plan that maybe includes contingent trust provisions that would take effect if at all at death? Go through, figure out what's our scope of work, what do we need to do, and then based on that, we'll say, here's the flat fee quote we're going to offer for this scope of work. Most of our clients, given the choice, will take that. But we always say, if you'd rather do it hourly, here's our hourly rates. Um,
Yeah.
what we'll do is we say if for example, if we say the flat fee quote for this probate would be $5,000, say, we'll say if you'd prefer to do it hourly, we will, instead we'll just take a deposit. That deposit is going to be higher because there's a chance the scope of, there's a chance that the work ends up costing more than that flat fee for you. On the flip side, if there's money
Yep.
left when we're done, you get a check back. Um, but we've found that clients like flat fees.
Predictable.
They like there's so much uncertainty right now. Being able to say
Yeah.
this is how much it costs is good, but it works for us too because we can say, all right, now our client is, we were always going to be as efficient as we could before, even if it cost us money. But now our client says, well, of course, my client, my lawyer wants to get this case done as quickly as possible, and so do I. Um, and it helps kind of alleviate that concern of every time I email you, the meter's running. Um, and so, and the way we're going to set up that flat fee is we're also going to say, we're going to build into it that,
Yeah.
it's in our client's interest to be quick and provide things we need as well. One of our frustrations is if the client says, when can you finish that inventory? Well, I can finish it when you give me the information I need. And sometimes it's kind of pulling teeth and like
Yeah.
I'm not a magician.
Same
I
with
can't
getting
make things up.
mortgages.
I can't create facts. I need the information. But so that's something I know not every estate planning, I think flat fees are pretty common. Probate, um, there's a few of us that do it. I think we're kind of in the minority right now, but we may see some of our colleagues come join us there. But
Nice.
we're happy to be able to offer that as an additional value that our clients can have a little better cost certainty during, like I said, already kind of an uncertain time.
Perfect. And where can people find you, or what courts do you enjoy working in certain courts, or does it matter for you?
We're based in Dallas. I'd say most of our work is in Dallas and Collin County, but we're happy to serve pretty much anything in the Metroplex.
Okay.
Um, but you can find us. Our website is ellenwilliamsonlaw.com. Talks a little bit more about all of our different practice areas, and you've only seen me, but I've got a team that helps support me. You can learn
Same
more
here.
about them as well.
Well, in the video too, I'll post all your links below. And if you could share the photo with me, or a photo I could put on like a thumbnail,
Of course,
I'll put it on this video for you.
that'd
And
be great.
not to brag a little bit, but I do like to market, so I'll make sure that a lot of people see this, because you did a really amazing job. I really appreciate your time,
Of
and
course,
I'll hopefully in a few weeks or months we'll share the results with you, and hopefully you get some future business from it.
that'd
I'll
be great.
definitely think of you in Dallas and Collin County and everywhere to help your practice as well.
Well, great, and yeah, likewise, I'll keep you in mind too.
Thank you, man. Thank you.